Mr. President, I rise to appeal the ruling of the chair. The proposed amendment is germane to the bill at hand because the bill relates to increased penalties, and the proposed amendment would repeal the bail and discovery reforms that have reduced or removed the ability of judges to impose appropriate penalties on dangerous criminals. Every day, New Yorkers are forced to deal with the effects of the disastrous bail and discovery reform as dangerous and violent criminals continue to be released without bail, free to commit more violent crimes. Crime rates are skyrocketing, and New Yorkers are much less safe than they were under the old bail laws. We have seen the devastating effect that these changes have had on our citizens. Judges' hands are tied by this ineffective and pro-criminal system as they're forced to release criminals without having the ability to exercise their discretion to hold an individual based on the danger that they pose to the community, or, in many cases, their history of failing to appear in court. Unless an offense falls within the narrow class of crimes that qualify for bail, judges have no option to set bail, even if doing so is necessary to protect the community or assure the defendant's return to court. Many offenders have a lengthy history of failing to appear in court or have a lengthy history of violence, including retaliatory violence against witnesses or victims. They must be immediately released at arraignment simply because the offense that they have committed is not sufficiently dangerous or harmful enough to warrant setting bail. And even when someone is charged with an offense that qualifies for bail, judges are only allowed to consider factors related to the defendant's risk of flight. Judges cannot consider the risk that the defendant poses to the community or those that they have victimized. Offenders arrested for serious crimes, such as breaking into and stealing from a business, felony driving while intoxicated, drug dealing, or animal abuse, are immediately released at arraignment, free to continue committing crimes. Since the bail reforms became effective in January 2020, crime rates have skyrocketed across the state. From 2019 to 2020, the murder rate increased by almost 50%, and gun crime outside of New York City increased nearly 30%. And we know that some of this crime has been committed by offenders who were released under the current bail laws. 3,460 offenders arrested and released committed violent felonies while out pending trial. 3,460 violent crimes could have been prevented if judges had full discretion to set bail in appropriate cases. We must restore common sense to our criminal justice system and give judges the discretion they need to set bail on dangerous offenders to keep New Yorkers safe. And for these reasons, Mr. President, I strongly urge you to reconsider your ruling.